The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. That's all right. You can. We have 5 cases that will be submitted this morning. I'll just tell you what they are. State of Iowa versus Scott Robinson. State of Iowa versus Jabari Walker. State of Iowa versus Jose Jaquez. State of Iowa versus Patrick Dudley. And State of Iowa versus Matthew Brown. Now, the Brown case will be submitted without argument, and we'll hear the other 4 cases in the order that I read them. We'll take a 10-minute break, no more than that, after the Walker case. So, Ms. Knipfer, you're ready, and you may proceed on State of Iowa versus Scott Robinson.
May it please the court, counsel. The right to counsel and meaningful access to the courts is a fundamental right of our Constitution. And this right was denied to the defendant by the Dubuque County jail system, in that it had, when the attorney and client attempted to meet, there was a plastic barrier between them with a hole to talk through, covered with mesh, and they found it very difficult to communicate. There were cameras that could record, though not necessarily recorded, and because they had such difficulty speaking through the barrier, there was concerns of being overheard.
The counsel, didn't the trial court offer up an expedited hearing if there was a need to meet with a barrier-free or private room, and then the trial counsel never followed up, right?
But his evidence would have essentially, the evidence would essentially been the same, that there was this barrier and all these things inhibited their ability to freely communicate. So it's not as though the court's going to change its mind. The evidence wasn't going to change, so it's unlikely that the court was going to change its mind.
Well, couldn't counsel have said, okay, we're 10 days from trial, I need to meet with counsel in a truly private setting to map strategy for the trial, to consider whether or not he would be called as a witness, and so forth and so on. And for purposes of trial preparation, 10 days out, let's just say, I need a truly private consultation.
But that's essentially what he's saying at this point in time also. I need to, confer privately with my client, and I can't do it under this setting. And
how did that interfere with their consultation? I know that the Walker case, the lawyer wanted to do some field tests for sobriety. He didn't want the video camera to capture that in case they didn't go well. He wanted to be able to perhaps do a PBT. He needed that barrier out of the way. What are the facts that show your right to counsel in this case was interfered with?
Because it interfered with their ability to freely communicate, to develop a relationship between the two of them, and the courts recognize, that that's basically it, is to freely communicate and to develop their relationship in a level of comfort that when you have this barrier, it prohibits that. And that's really essential when you're trying to develop a client-attorney relationship, because you need your client to be comfortable with you insofar as so he will, tell you everything that you need to know and feels that you are freely communicating with him.
Well, let me ask you this question. I understand from your briefs that you say, well, generally speaking, you're entitled to barrier-free counsel absent a specific showing of violence or some such thing, and no one claims that was there. In this case, I don't believe. But even if there was a violation of right to counsel, there's a question of remedy. And of course, we have this in the state's brief. And considering remedy, we really have a number of questions. First, is it a per se problem? And then second, if not, if it's a harmless error kind of analysis, there'd be a question of burden of proof. Who has a burden of proof? So why don't you address those issues, please? There wasn't, in one sense, there wasn't an absolute denial of the right to counsel. I think rather clearly if there was an absolute denial, I think all of us would say that's a per se violation. But we didn't quite have that. The counsel had an opportunity to meet on several occasions, albeit with this barrier. Make the case that it should be a per se violation, or that the state bears a burden of proof on harmless error and failed to meet it.
Well, in Walker, they found it was presumed violation, and
Well,
if you look
except, yeah, there's a presumed violation, except it seemed to me, if I read Walker correctly, the state would have had an opportunity to show harmless error.
right, and at least then it's the state's burden to prove otherwise. But because this goes to the heart of the client-attorney relationship, it really, it's not a total denial of client-attorney, or a total denial of counsel, but it's pretty darn close. Because how can you be represented by counsel if you can't fully communicate? And I gave additional notice of authority in the Barber case. And in that case, it talks about how, if you're putting the defendant in the position of proving why he's prejudiced, but that puts him in the position of like revealing client confidences or trying to prove a negative. And I mean, it's just that this type of situation isn't amenable to proving prejudice. So it's more analogous to the waiver of counsel cases where, the client can't prove prejudice if he wasn't properly waived, if he didn't properly waive counsel. In fact, likelihood, he was better off in having counsel. But, that isn't the issue. The issue is that he wanted to go pro se. Anyway, and he wasn't properly advised of that, of the risk. So we just say that's a structural error and it's reversed. This is a similar type of situation where it really is a structural error because it goes into the heart of the attorney-client relationship. And so it should just be reversed in this type of circumstance.
What do you make of the Colorado cases that seem to suggest there has to be some kind of showing of prejudice?
Well, like the Parsons case.
Let's try that.
Okay.
For starters, yeah.
Well, in Parsons' case, they actually did get to have confidential meetings because they were allowed to use the jury room, and then he could demonstrate whatever it was that he had to demonstrate.
Well, but here, don't you think if counsel would have said, well, I need to demonstrate, you would have gotten the same kind of relief that Parsons got?
Well, here they weren't really talking about having to demonstrate anything. It was more of a communication problem and worried that their communications weren't fully private.
Let me get right to the chase. What's bothering me about the case. I understand your right to counsel argument, and as I read the majority of case law, it suggests that you're entitled to a barrier-free counsel absent a showing of violence or some such thing, and that wasn't here. But the cases also seem to suggest that in order to be reversible error, and I'm not sure where the burden falls, but in order to be reversible error, there has to be some showing of harm. And here, aside from the generalized assertion that you're making, I'm struggling with the question of harm.
Right. And really, again, it just goes into that lack of free communication and client relationship and forcing the client to have to, lay out his hand to the state in order to prove his right to have this confidential meeting.
Question on you. And I just suppose we were to find that there was a violation of right to counsel, that the burden is on you to show that there was harm. Where would that leave us?
I need you to ask the question again.
Supposing we said it wasn't a per se problem, and I know you disagree with that, but supposing we said it wasn't a per se problem, and that it was the burden of the defendant to show that there was harm, could you show any specific harm?
Well, in this particular case, or in general, I think you put the defendant in an impossible situation. Because, again, it goes back to being forced to reveal your hand and to prove it, a negative. You don't know what would have happened or what would have been communicated had they had the full ability to communicate in private.
Let me shift it. Supposing we said that there is a harmless error doctrine here, but that the state has the burden of showing it was harmless. Would the state have met such a burden in this case?
I don't think so, because they cannot prove that there wouldn't have been, again, they're actually in the same boat. They can't prove what would have been communicated or what was not communicated or how it was not harmful.
Well, let me put it this way. If there is no showing of prejudice, is there really a barrier-free issue that the Constitution would be concerned about?
Well, see, that's the problem here, is that you give the defendant a right, and then you provide, and then there's no way that he can, obtain. If he's ever denied it, there's no reason. There's no reason for the state to ever have to live up to its obligation, because defendants put in the impossible situation of not being able to show prejudice, because this unique type of situation, he's put with this problem of, again, having to reveal his hand or try to prove a negative, because we don't know what those confidences would have been had he been able to fully communicate.
Well, a barrier, puts forth the idea that there's some obstruction that's preventing the necessary communication between attorney-client. But is there really an obstruction that the Constitution would be concerned about if the communication, that is the lack of communication or the difficulty in communication doesn't cause any prejudice?
Well, we're saying that it does. And the courts have recognized that it does.
Well, and in this case, because like in Walker, we said under the specific facts of this case, what are the specific facts of this case to show that there was a violation? Well,
Walker was a unique case in that you really could point to something, because there was something physical that he wanted to obtain. He wanted to smell his breath. That's actually pretty unique, and it was very focused. And the other thing with Walker, we're not really talking about like an access to the courts kind of problem, or the communication that relaying to the courts, because your right to attorney has attached, and you're developing your defenses, and some of that is going on in Walker, but really what he's trying to do is determine, am I going to let this guy take the breath test? And that's just a different fact scenario. And so in this case, we're really talking about developing defenses, trial strategy, and just the whole client-attorney relationship. And the courts have recognized that is extremely important and is essential in your right to access to the courts. And that's why we have all these primarily prisoner cases, but all these other cases out there saying this is an essential right. And then when it comes to the attorney-client clients, they have right to barrier-free access.
Let me ask you about the kidnapping aspect of the case. And the, assuming that we thought the standard for establishing a separate kidnapping count was some kind of increased risk of harm. In this case, as I understand the facts, the victim was at one point outside the apartment, then came in to retrieve a cell phone, and that at least the allegation was, and substantial evidence supported the view that the defendant grabbed the victim, locked the front door, pulled her into the bedroom, I think, locked the bedroom door, and then thrust her on the bed. Make your best case that's not sufficient for kidnapping. It's obviously true that the movement was 20 feet or whatever. Not a whole lot, though. Movement all occurred within the apartment. But the locking of the doors, and also I think the gagging of the mouth, the state would suggest is enough to establish increase of harm and a kidnapping. Why don't you respond, please?
Can I answer it? Well, first of all, this is not this is a confinement case as opposed to removal. And the locking of the door, it doesn't prevent her from getting out. And when he takes her back to the bedroom, the question isn't, was there confinement in the three-factor test? The question is what the confinement above and beyond exceed the sexual abuse. And all his actions are very similar to the case in Marr. In Marr, he put his hand over her mouth, just like in this case. But he didn't attempt to tape her mouth. You look at the other cases that talk about gagging, they tape their mouths or something like that and restrain them, bind them. There are other types of physical restraints involved where, in this case, it was simply the hand. And in Marr, it was simply the hand. And in Marr, like this case, he took her around the corner. It was all part of the sex abuse. In this case, he goes to the bedroom, again, for the purpose of the sexual assault. He never does anything above and beyond the sexual assault.
Could have sexually assaulted her on the couch.
He could have, but this, again, it still doesn't go to anything above and beyond a sexual assault here. Marr could have sexually assaulted the woman right there on the street, but he took her around the corner.
Thank you, Counsel. Mr. Bowler.
Thanks.
May it please the court, Ms. Knipfer. Good morning, Your Honors. My name is Tyler Buller, and I represent the state of Iowa. A criminal defendant does not have a right to a barrier-free meeting when he offers no reason or any reason at all in support of his claim. The defendant...
Well, that's not... the case law basically says you do have a barrier-free right unless there's a specific showing of violence or some other... isn't that right? Boy, oh boy, there's lots of cases that say just that.
There are many cases that talk about where the burden falls, but almost unanimously, those cases include a statement to the effect of a defendant does not have a right to carte blanche access, is the language one court uses.
But there has to be a specific, some kind of specific showing. In other words, as my reading of the case law, and I invite you to challenge it, of course, that's why we're here, but my reading of the case law is that the presumption is you get barrier-free counsel, and the burden is on the state to show some specific reason why that cannot occur. Now, challenge that viewpoint and help me with some authority or some reasoning as to why that isn't so.
Justice Apple, I think it's a little muddier than that. What we see, even in the cases that talk about the presumption, is a statement that defendants don't have this carte blanche right. If we look at, for example, Eighth Circuit cases like McMaster as Wiegand, we see the courts discuss how reasonable deference is given to jail administrators. That's a
sure, but they have to have a reasonable deference means there has to be some kind of reason to say you don't get it. we're concerned about drug trafficking, we've had a big problem with drug trafficking in the jail, blah, 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 da, da, da. I mean, some kind of specific showing. But if I understand it, and again, correct me if I'm wrong on the record or the law, but as I understand it, Dubuque has this barrier, and everyone basically who is arrested and in the jail talks to counsel through the barrier. And doesn't that pose a problem for you?
No, Your Honor, I don't think it does for a few reasons. First, if the defendant had come forward with really any reason that made sense for needing a barrier-free meeting, the district court in its order made very clear that the defendant would have been given the meeting in that circumstance.
But is that a good order, though? That's my problem. I mean, why should the defendant have to come forward and say, I want to do certain things, when it would be it seems to me the better position that a defendant gets a barrier-free meeting unless the state or the jail, in this case, comes up with a reason why they shouldn't. And you know, we're past that point, though, because he went to trial and everything else. But is it the state's position that it's the defendant's burden to ask for a barrier-free meeting and only get it if he or she has a legitimate reason? Is that the state's position?
At the outset, the state has a minimal burden, Your Honor. Under the case law, the state has to show a reasonable relationship to a penological goal for its policy. And we have that here. The jail administrator from Dubuque testified that the purpose behind the policy was jail security and orderly jail operations. That's enough to make it so that when a defendant requests a meeting, he has to offer a reason, something like he wants to review DVD evidence, he wants a final preparation before his trial. And in those circumstances, the record here shows that defendants in the past were given barrier-free meetings, and the district court's order makes very clear that if the defendant came forward with a reason, he would have been given that opportunity here.
But didn't you already present the reason? I mean, the argument of your opposition is that, look, effective attorney-client relationships require establishment of a rapport. Lawyers always worry about that. When we interview clients, we want to do it in a conference room that's kind of comfortable. We want to do it in a setting that allows for effective communication. Yeah, in the criminal justice system, defendants are often very suspicious of lawyers, and et cetera, et cetera. So as I read the hearing, the general argument was made, at least, that, well, we need to establish this kind of rapport. That's what attorney-client relationship is all about. And isn't that sufficient?
No, Your Honor. There are two problems with that argument. There's a proof problem and a law problem. The proof problem is we don't have sworn testimony in this case about exactly what the problem with the barrier was. We have a brief legal argument that's made by Mr. Drezal below, but unlike in the Walker case, there's no professional statement. Mr. Drezal wasn't put under oath. He wasn't subject to cross-examination by the state. His statement to the court isn't evidence. Instead, the defendant's argument seems to rest on this sort of fluffy concept of emotional bonding.
He says as a matter of law, I'm entitled. I mean, it was a legal argument. I think you characterized it correctly. But his legal argument was, as a matter of law, I'm entitled to a barrier-free counsel, unless they come up with a specific reason that's specific as to this defendant, by the way. I mean, that's their argument, as I understand it, specific as this defendant or this lawyer. And, of course, you can see that wasn't made here.
I agree with that, Your Honor. We do certainly have some general evidence of violence. The defendant was picked up on a Class A felony. By definition, that's the most kind of violent crime that we have under the code. But as to whether this particular defendant had disciplinary problems, for example, I agree, Your Honor, he didn't. But the state's burden is minimal. The general evidence the state offered about jail security, orderly jail operations, and that the defendant was picked up on a Class A is sufficient to shift that burden.
So a general rule to keep the jail orderly can trump a constitutional right?
No, Your Honor. The rule has to be reasonably related to legitimate penological interests. And I think our evaluation is somewhat fact-driven. I think the Walker court correctly stated it, that decision was based on the specific facts of the case. If we look at the facts here, the facts are very different. The defendant hasn't offered any reason why he needed that barrier-free meeting, except this concept of emotional bonding. And I want to talk quickly about the law problem with that argument. Both this court and the Supreme Court have said that the Constitution doesn't guarantee a meaningful relationship with counsel. And that's certainly right. The relationship between a criminal defendant and his lawyer doesn't have to be as comfortable or as cozy as if I walked into a downtown Des Moines law firm. The Constitution sets a minimal threshold, and that threshold doesn't include emotional bonding. I think the 10th Circuit said it best. There are simply no cases presented to us in which courts have measured counsel's effectiveness by the strength of counsel's emotional bonds with the client.
You agree, first of all, it wasn't tried on a removal theory, only confinement, right?
That's correct.
All right. What if the defendant had simply closed the bedroom door and not locked it? Enough evidence to support first-degree kidnapping? I mean, most people close the door when they're going to have sex.
That's a tougher question, Your Honor, but I do still think there's a jury question generated on that issue. It's important to remember we're not talking about de novo review of the facts. That particular fact, viewed in the light most favorable to the state, especially with the context we have in this case, could have been proof beyond a reasonable doubt of confinement.
So the state's position is if an individual forcibly has sex with another person against that person's will after closing the door, that's enough evidence to get to the jury on first-degree kidnapping.
The state's position is it can be, Your Honor. We look at the three factors: increased risk of harm, reduced risk of detection, and if escape is made easier.
Well, let me look at the instruction here, if I could. I mean, the instruction says, you're right, they talk about risk of harm as something the jury may consider, but all the jury has to find is confinement requires more than what is included in the commission of the crime of sexual abuse. That strikes me as a very lax, open-ended standard, because there's always going to be something more going on than sexual abuse.
Well, the standard may be open-ended, Your Honor, but I don't think the three factors are separate from that analysis. I think the three factors are tools the jury can use to evaluate whether the kidnapping is more than merely incidental.
What do you make of the Marr case? There's two features of the Marr case that are interesting. One is there was some around the corner. And although this is a confinement case, I think the court's analysis in Marr is still a little interesting. The movement was incidental to the underlying crime, and there was some element of gagging in the Marr case as well. So why don't you help me with that case, please?
The facts here, I think, go beyond Marr, even if Marr was correctly decided. And
You think maybe not?
I think the Marr discussion blurs the lines between confinement and removal at times. I wouldn't say it was wrongly decided, but the analysis blurs those two components.
I agree with you completely, by the way. But the thing of Marr that maybe is not blurred is this notion of what is incidental to the underlying crime.
The facts here go beyond Marr. We have the defendant taking away Becky's cell phone, throwing it out of her reach. He locks the front door. He drags her by her hair from the living room to the bedroom.
But again, it's not a removal case.
No, Your Honor, but some of the facts that would support a removal case also support a confinement case. The process by which the defendant confines the victim is certainly relevant. The jury instruction talks about how confinement can occur either at the point the interactions begin or where they end up. So the process by which the defendant drugged Becky by her hair to the bedroom is relevant.
What was actually the confinement? How was she confined?
Becky was confined because the defendant locked two doors.
But she could open the doors if she could get to them, right?
Well,
I mean, they were locked only from the inside. So from that perspective, it's no different than just closing the doors, right?
I think the important distinction in your question, Your Honor, is if she could get to them. And she couldn't because the defendant was confining her by holding her down on the bed, by putting his hand over her mouth.
But isn't that kind of common to a normal rape situation?
No, Your Honor. The defendant didn't have to put his hand over Becky's mouth to stop her from screaming in order to sexually abuse her.
Oh, so, I mean, is it really possible that whenever in a sexual abuse, if if there's evidence that the defendant covered the mouth of the victim, that makes it kidnapping? Just that?
That on its own, probably not, Your Honor, but we have a lot more than that here. We have the cell phone taken away, we have 2 locked doors, we have the hand over the mouth, we have her held down on the bed. And then after the defendant did all of this, he said, "You like getting raped just like the rest of them." The defendant was trying to reduce the risk of detection.
It's no question is the evidence demonstrates it was a brutal crime, and the issue is not whether it was sexual abuse. The issue is, was there confinement, which makes a huge difference. It's a life sentence without parole for this individual. Where exactly is the confinement? Throwing away the cell phone doesn't confine her. Locking the door from the inside, how does that confine her when she can open the door from the inside as well?
Your Honor, it's a combination of all of the factors, and it's important to remember here that the defendant wasn't able to complete perhaps all the sexual acts he hoped to. The police broke down the door, and one of the reasons that the second locked door, the locked bedroom, is important is because if the defendant had continued sexually abusing Becky, that would have facilitated him not only getting outside, but also holding her in that room and potentially sexually abusing her for an even longer period of time. Part of the defendant's argument is that the confinement didn't exceed the sexual abuse because chronologically they were the same. But the only reason that is true here is because, in a very small way, Becky was fortunate. She was fortunate that someone heard her screaming, despite the defendant's best efforts to silence her. The upstairs neighbor called the police.
Was the jury properly instructed?
Your Honor, that question isn't properly before the court except as an ineffective assistance argument. The jury was properly instructed in the sense that counsel didn't breach an essential duty, certainly, because we have the Ripperger case. It's a controlling and published decision of the Court of Appeals, and it says that the exact instruction given here was fine.
It'd be a better instruction if it had added the word significantly.
It might have, Your Honor, but that's not the question in front of this court.
Counsel, could you just physically describe the locks on these 2 doors?
They're a little difficult to describe, and I think in the discussion between the state's brief and the defendant's brief, we see a little bit of disagreement about that. I would encourage the court to look for themselves at the doors, or at the locks on the doors. It's sort of what you imagine in a typical house, but they might be a little bit sturdier. On one side, there is a entry point for a key, and on the other, there's a little button that can turn or be pushed. Does that address your question, Your Honor?
So, I'll ask it just one more time. The court is circling around here, and you are too, but there's no doubt that the victim was confined in the sense of confined on the bed. There's no doubt that the bedroom door was locked. But surely it's different from cases where the confinement often happens after the crime, or before the crime, or in a different location. And we are instructed, I take it by our case law, that incidental, that there's some, it gets a little fuzzy on the margins, I guess. I mean, we have to determine what's incidental and what's not. The locking of the door, the gagging, it seems that a fair argument can be made that that's incidental to the underlying crime with respect to confinement.
Your Honor, if I might answer. I don't think it is, Your Honor, and there's an important distinction between whether we might think something is confinement and whether the jury did in this case. It's a very deferential review. The totality of the circumstances here would allow a reasonable jury, using the 3 factors in the instruction, to conclude that the defendant confined Becky. We aren't just talking about one act in isolation. We're talking about a hand over a mouth, holding her on the bed, locking 2 doors, dragging her from one room to another by her hair. That, taken in the aggregate, is sufficient proof for the jury to return the conviction they did. And I'd ask that this court affirm the defendant's conviction.
Thank you, counsel. Rebuttal argument.
None of the, That's, no, my understanding is anybody could turn the lock and the door would open, and that the restrictiveness of the locks was the key you had for the outside. You needed a key to get in.
So someone outside the bedroom door, the door's locked. Inside, you can turn it just as your typical motel room. You can get right out.
That's how I understand it. The states that argues that the fact that the door is locked and that the defendant was holding her and that he threw the phone, that these are all these all show that there was confinement. But all these things are part of the sex abuse. And if you look at all of our kidnapping cases and compare them, I mean, Mars stands to one side, and then the remainder of the cases, there's always binding, taping, staying in the apartment beyond the sexual abuse. And Rich, after the sexual assault, he puts her in a garbage can and hauls her around the mall. In McGrew, I believe, he stays in the apartment for an exceeding length of time until she escapes on her own. This is not going on in the present case.
Was the jury properly instructed? And if not, was that issue preserved for this appeal?
I believe that, no, it has to be raised in effective assistance of counsel. Another point is the state argues that, that all these possible things could have happened had the police not broke down the door. But we don't punish people for what might have happened. We punish people for what did happen. And in this case, there was no kidnapping because there was no confinement in excess of the sexual assault. I want to jump back briefly to the barrier-free contact. One of the problems here is in this case, you have a blanket application of the barrier-free, or the barrier between defendants and their clients. And the law prohibits any kind of blanket restriction. You have to have an individualized determination of a need for that barrier between the client and the attorney. Another problem here is that these kind of restrictions is punishing indigent defendants, because if you were a client that could bond out, then you could meet in a confidential setting of the attorney's office.
I agree with that, but doesn't that argument prove too much? I mean, when I was in practice, it was always easier, way easier, to work with a criminal defendant who was not incarcerated, who was not in jail at the time. And there's no way you're going to close that gap, right?
I mean, it presents a problem, but I mean, it's a particular problem in this situation where you don't have any reason for the barrier. And so you're punishing this client for not being able to afford to bond out. So for the reasons I've stated here and in the brief, defendant respectfully requests that this court reverse his conviction and remand for a new trial.
Thank you, counsel. The case is submitted. We'll now hear the Walker case.